Alex here with the legal nuts and bolts video on interrogatories. As I mentioned in my previous video, this is going to be a four-part series on these different discovery tools. Interrogatories is going to be the second video of that four-part series. If you haven't seen my previous video on requests for admissions, it's a good idea to check it out because it kind of goes into the whole premise behind how these tools are supposed to be used. I'm not going to go into it as much detail in this video because I covered a lot of it in the last video. So I'm going to go straight into interrogatories now. And I will do a little bit of compare and contrast with requests for admissions. So first off, interrogatories is a list of questions that you can send to your opponent that they have to answer. In my previous video, requests for admissions worked in a very similar way, but with requests for admissions, your opponent would have to admit or deny each statement that you sent them. With interrogatories, you are asking for an open-ended answer. There's a big difference there. There's a big difference between whether your opponent can admit or deny something, and that's it, or whether they can provide an open-ended answer, and that's the way interrogatories work. You're going to want to put questions into the interrogatories where a simple admission or denial is not enough for you to know what to do with it. One example I gave in my previous video was a request for admission like, I forgot to take my child to school 7 times last year. That statement requires them to admit it or deny it. I admit that, or I can deny it, and that's it. With an interrogatory, you could instead say, how many times did you forget to take your child to school? So that's a more open-ended question. They're not going to just admit or deny that. They're going to say, I forgot to take my child to school 3 times. That's all it is. It's the only difference. One of the nuances that I mentioned with requests for admissions was that if your opponent failed to respond to them in time, that the requests for admissions were deemed admitted. Well, that doesn't apply to interrogatories. If your opponent doesn't respond to your interrogatories, you're going to have to compel them to do so. And if they do not comply with the court's order compelling them to do so, it's going to get a little bit tricky as to how you can proceed beyond that. There's all kinds of tools, sanctions. You could just outright win your case. There's all kinds of things you can do. I'm not going to go into that with this video. I'm just covering interrogatories. And in fact, that's really all that you can do with interrogatories. As I mentioned in my previous video, I don't like to go over things twice, but I will say this because it's a pretty big thing with the way interrogatories are supposed to work. Is they're supposed to cut down on some of the fog with regards to your opponent's position. When you oftentimes sue your opponent, it's unclear as to what they're going to say. It's murky, it's foggy. You just don't know. You often have planned for a certain response or two, but without knowing exactly which way your opponent is going to go, the possibilities as to what witnesses you're going to need and what evidence you're going to need are endless. And so interrogatories can be so useful because you can read the responses to your questions, and based on those responses, you can decide, I don't need this witness now. I don't need this documentation. I don't need, to go over this issue because they've answered it in a way that's good enough, for me. That's it. That's the end. She said she forgot to take the children to school 3 times. So, I don't need to bring the teacher. I don't need to get the attendance report. That's exactly the truth. That's what I thought it was. So now you can move on to other issues. So, same thing as with requests for admissions. You use the interrogatories to get answers to questions before you go to court so that you know how you are going to, how are you going to present your case, because, as I mentioned, other issues are now resolved ahead of time, or now you can devote your attention or time to a different set of witnesses and research because your opponent is putting their eggs in that basket instead. They're going to fight on that issue instead. You never know which way your opponent is going to go, and that's one of the reasons that formal discovery proceedings can be so invaluable, is because you can start to get a gist as to which direction they're going to take, and you can figure out how you're going to deal with it when you eventually get to court. So with that, I'll go ahead and end this video. If anyone has any questions, feel free to post it in the comments below or send an email. I'll see you guys next time.